Hello and you're welcome to our second lesson in PPL 518 Alternative Dispute Resolution 2. Do you remember what we talked about in the last next lesson? We defined arbitration and we talked about people's opinions on whether arbitration is better than litigation or not. So in this lesson, we're going to be moving on, defining three words: international, domestic, and commercial. And then we'll be looking at the types of arbitration, types, categories of arbitration. So let's begin. Okay, so by the end of this lesson, some of the things you should be able to do if you understand everything is to explain what we mean by commercial, international, and domestic as it relates to arbitration, of course. Differentiate between international and domestic arbitration, discuss the concept of arbitrability, and you should be able to analyze the types of arbitration. And so, what do we mean by commercial? There's a general layman's definition that is, of course, the always the rule. However, there's no clear interpretation where arbitration is concerned. Now, determining what to interpret as commercial differs from country to country. So, some countries may adopt a narrow definition, but the international approach and recommended by UNCITRAL is to follow the wide approach. So, to define or interpret commercial to cover as many commercial relationships as possible. The definition of commercial is important because some countries determine which issues are arbitrable on the basis of what their jurisdiction sees as commercial. So, where an issue is not classed as a commercial transaction in that country, then when the issue arises for arbitration, they don't determine it as arbitrable. That is referred to as commercial reservation under the New York Convention. And this will have an impact when it's time to enforce, a foreign award. Now, international, what do you mean by international? Basic English again, transnational. So it goes beyond domestic and national boundaries. So what you imagine is that the parties to a transaction are from different countries, or the place of arbitration is different, or parties by themselves agree that they are the any dispute that arises should be treated as an international a dispute that should be subjected to international arbitration. Again, we wonder, why do you need to interpret a basic English word in international? Because arbitration does not have a connection with a state, really. So even when you parties sit together in a particular location, that is just geographic. It's not fundamental. And then international arbitration is always a better option for multinational countries, corporations, and state parties. So one the features of international arbitration that you must bear in mind is that it is hybrid. It is not fixed to a particular system of law. So the IBA have, rules where they mix common law and civil law rules, in order to come up with rules for international arbitration. And then there are no limits to parties' claims, parties, what parties can resolve, and all of that. And then parties, of course, are at liberty to choose what they want to do. And you will find that with the growth of arbitration, international arbitration has contributed significantly to the growth of arbitration. It has become very popular. Many multinational companies and state parties don't even bother with litigation anymore. And of course, there are advantages to international arbitration, which we will talk about in the course of, the arbitration dispute resolution too. Now, what is domestic arbitration? Domestic arbitration, again, is, think about it in basic English, local. So usually it involves small but important claims by private individuals. Remember and distinguish that from international, which is large claims, multinational corporations, state parties, and all that. Unlike commercial and international, which don't have definite, interpretations. Domestic arbitration has definite interpretations, but they differ amongst jurisdictions. So in the UK, for instance, the Arbitration Act 1996 points out, classifies a domestic arbitration agreement as one where the seat of arbitration is in the UK. It involves parties who are either nationals or habitual residents of the UK, or where the party is one of the parties or both parties are corporations. The corporation is incorporated or has central control in the UK. So where any of these features are in existence together, then you will say that the arbitration is domestic, except parties specifically agree to classify it as international. And then in India, the Indian definition of domestic arbitration goes a bit further, than the UK. First of all, it points out that it has to do with a dispute arising out of a legal relationship, whether the relationship is by contract or not. Then, beyond nationals and habitual residents and corporate bodies incorporated in India or controlled in India, it goes ahead to say that other parties to domestic arbitration could be an association of or body of individuals, again with central control and management in India, or a government which is not foreign. So that those are the two definitions of domestic arbitration. Now, why is it important to distinguish between international and domestic arbitration? First, because different rules apply to either of the two. Remember what we said, that under international arbitration, there's a hybrid of rules. For domestic, there are strict rules. So there are limits on the extent to which national courts can intervene. For international arbitration, the limits are very strict. For domestic, well, can be, not so strict. And then again, enforcement is an issue. For multinational issues, usually when it's time to enforce, parties may go beyond a particular state to go and enforce in another country, and so on. The distinction arises as to whether it is international or domestic, because if it's international, then under the New York Convention, enforcement becomes easy. And of course, you know that for international arbitration, parties are from different backgrounds, different legal systems, different principles, and all of that. Okay, I'll give you some time to think about it, and then we'll make progress. Okay, progress. Now let's talk about arbitrability. What does it mean? Arbitrability means it answers the question, really, whether or not arbitrators have authority to rule on a dispute that has come before them for settlement. So, is this dispute capable of settlement by arbitration? That is the whole point of arbitrability. And on this point, you look at Article 2 sub 1 of and Article 5 sub 2 of the New York Convention. Now, arbitrability is fundamental. It goes to the root of proceedings. So it's like jurisdiction in ordinary courts. So it's what clothes the arbitral panel with the authority to be able to deal with an issue. So if a matter is not arbitrable, they shouldn't even start looking at it at all. Okay, so when a claim can be settled by arbitration, you say it is arbitrable. If it cannot be settled by arbitration, you say it is non-arbitrable. And again, arbitrability will depend on national laws, judicial discretion or interpretation, and all that, and then public policy. In some countries, rules of public policy differ, and so different standards are set by different countries when arbitrability. Now, when are issues of arbitrability raised and where? First, at the beginning of the process, a party can raise it, and then the panel will be required to rule on its own jurisdiction. Second is where a national court is required to rule on whether an arbitral agreement, relates to a matter which is arbitrable. Third is, again, in the course of proceedings where a national court is being asked to set aside the proceedings on ground of non-arbitrability. Then fourth, where enforcement, now an award has been given and enforcement, recognition and enforcement is about to be done. The court to whom, which is being asked to recognize or enforce, can be asked to explore the issue of non-arbitrability. Okay, so now let's look at what issues are arbitrable and what issues are not. Generally, civil or quasi-civil issues are arbitrable. Commercial disputes are always arbitrable. Remember the definition of commercial that we talked about in UNCITRAL, making it very wide. And then, of course, any dispute where parties can reach a settlement privately, they can validly do that, will be arbitrable. Non-arbitrable issues where the procedures, will impact on the general public or public interest or public authorities, they will not be arbitrable, because the arbitral tribunal does not have the authority to make rulings that affect the general public or public authorities. Remember our definition of arbitration, we said it is private. Okay, so examples of this will be criminal proceedings, proceedings that relate to family law, so succession, domestic disputes, and all. You must note that in some countries these are arbitrable. Issues that relate to validity of patent, because patent is, registered. It's subject to public registration. So the arbitral authority, for instance, cannot begin to order the public authority to register a patent. Matters that involve multiple persons, because again, they don't have the authority to join. Then consumer protection, because there's a need to protect consumers from undue influence by strong and producers with deep pockets. Okay, so there are two major kinds of arbitration that you have to bear in mind. There's ad hoc arbitration and there's institutional arbitration. Ad hoc arbitration simply means where the parties to a dispute by themselves select an arbitrator or arbitral panel on a one-off basis. They are the ones who make arrangements for venue and all of that. They don't go to institutions. They do it, one-on-one, on personal basis, albeit official, with whoever the arbitrators that are chosen. The other form of arbitration is institutional, and you have specific arbitral institutions that offer ADRO services, one of which, of course, is arbitration. So there are many, there are over 1,000. They can be specialized, meaning they deal with particular issues. For instance, the Court of Arbitration on Sports only deals with sports issues, or they can be general, so they can deal with any issue that is brought before them. They can be regional, they can be international, they can be local. So an example of a local arbitral institution will be the Lagos State Multi-Door Courthouse. And then most times institutional arbitration, because of the expertise and the cost and all of that involved, institutional arbitration is usually used for resolution of international disputes. Now, some advantages of institutional arbitration. If you look, you can see I've put some logos of various arbitral institutions. So the London Court of International Arbitration, we talked about Lagos Multi-Door Courthouse, Court of Arbitration for Sport, International Chamber of Commerce, WIPO, and all that. They are very many. It's important that you note this. So saying these five does not mean they are just five. They are over 1,000 and they are growing. You have OHADA, you have so many. Okay. Now, advantages. First, the rules are already in place. Each institution has its rules, arbitral rules, that will guide proceedings if you submit yourself to them. And so you don't have to start sitting down and agreeing on the rules. And then, of course, they have staff who are trained, employed, trained personnel who can take care of particular issues and who have the expertise you may need to offer specific services, for instance, to review draft awards and all that. And when you select institutional arbitration, they come with those personnel. And then, of course, fees for arbitrators are fixed. So parties don't get involved in trying to negotiate with any individual and all of that. And then because of their nature, they are most likely to be neutral. So for instance, the London Court of International Arbitration is an institution of choice because you know that though it is situated in London, it's not biased in any way or will not lean to any party. And you'll find out in the course of this not this lecture, as we go on in the course, you will see different cases that have gone before different arbitral institutions, and you see how clear, how transparent they are in their proceedings. Okay, so to our last activity before we call this a day. Now, some people will say that institutional arbitration is preferable to ad hoc arbitration. I want you to now ask yourself, do you agree with them, and why would you agree or disagree? So a few seconds, or while you just take some time to think about your answer. So if you have any questions, please post it to the forum and I'll be glad to answer. And we could even discuss it, and you benefit from other opinions and all of that. And so until we meet again for our next lesson, take care and keep your mind in arbitration. Bye.